Carried. All persons having anything to do before the Honorable, the Justices of the Appeals Board, now sitting at Boston, within and for the Commonwealth. God here, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. This is not a late start. We had an argument on Zoom this morning, and so that has caused us to be a little delayed coming to the courtroom, but I assure you we've been hard at work. My name is Amy Blake. I'm pleased today to be joined by Justice Eric Neyman and Justice Peter Sachs. We are your panel for the remaining 5 cases on today's list. I know most of you have been here before. Just a quick reminder, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read everything, so you should get to the heart of your argument. And in the event that something is impounded, please be mindful of that. And I will remind you as we get to the impounded matters. So with that, we will call the first case, which is Commonwealth versus Alexander Sodo, docket number 23P1111. Counsel, good morning.
Good morning, Justice. Dana Goldblatt for Mr. Sodo. Search incident to arrest cases can be very factually intricate and require a lot of really careful application of law to facts because those searches can take place right on the line of permissibility. This is not one of those cases. The defendant was in the hallway. He was handcuffed. He could not reach the bag in question. He had never been carrying the bag in question. And all of this is undisputed on the record. The bag in question was inside the apartment, and the officer searched the bag. And it was
I have a question, though, about that. You say it's undisputed he was never carrying the bag. As I understand, I've listened to the 911 call several times. We may not have known which individual, but the caller certainly reports that one of the individuals has a book bag. So how is it undisputed that your client was never carrying the bag?
The officer testified at the hearing that the client was not carrying the bag at the time of the arrest. So
but you say it's uncontested that he wasn't carrying the bag. He certainly could have been carrying the bag while the caller watched the robbery on the Ring camera.
Oh, sure, maybe.
Okay,
that
you're
might
not
have
saying
been,
that.
No, just that at the time of the arrest, it wasn't a personal effect. It was inside the apartment. And
Was it inside the apartment or was it in the doorway?
it was inside the apartment by the doorway was the testimony. And the issue was that it was also never established that that particular bag was the bag that my client had been carrying. So there's
Were
just...
there other bags recovered?
I don't know if there were any recovered, but it was an apartment building. It was an apartment.
Would you agree that there was probable cause to search the bag? I mean, if the police had gone for a warrant and had the apartment resident just stay there, or an officer stay there while the bag sat there?
Oh, yes.
Okay.
Absolutely, probable cause to search the bag. It was in the apartment. They didn't know which bag might be the one that my client was carrying. There was a bag that he was carrying. Also, a little bit of cultural background is, interestingly, the man who called 911, the robbery was of his drug stash that those police officers had been trying to get to for months. So it was one of those, like...
Is that in the record?
Is that in the record?
No, but it's a little bit of culture for...
Can't consider that.
I know, but absolutely probable cause. No one is ever was contesting that there was probable cause of the bag.
Let's focus on the issue before us. I think it's safe to say that your argument on appeal largely hinges on Gantt. Is that
Yes.
correct? Okay. Was Gantt raised in the motion to suppress or the memorandum in support of the motion to suppress?
No, there was no memorandum in support of the motion to suppress for Fourth Amendment.
Okay. Was it argued to the judge?
No, because the prosecutor never argued that this was a valid search incident to arrest. So no authority was offered on that.
Okay. But if... I'm having some difficulty getting our arms around addressing an issue that wasn't, at least in the first instance, addressed by the trial judge. I think there was a motion for reconsideration filed, or at least something that was taken by the judge as a motion for reconsideration, and you say in your brief, well, the Commonwealth says there's no appeal of a motion for reconsideration. In your reply brief, you say, well, there was no motion for reconsideration. Don't you have an obligation to file a motion to reconsider if a judge decides a case on a certain basis? And your argument is, well, on this alternative basis, you must still suppress it. That has to be brought before the trial judge or the motion judge in the first instance, doesn't it?
Yeah, if that had happened, certainly I would have been required to do that. But in this case, the issue was squarely before the judge, before the motion to reconsider. The requirements of filing a motion to suppress are on the defendant, are simply that you identify the search and the fact that it was warrantless, and then it's up to the prosecutor to identify any alleged exceptions to the warrant requirement, and that would make it reasonable despite the prima facie case that it was unreasonable. So in this
Right, but
case...
didn't you just say before, and perhaps I misunderstood you, that the judge decided this on a basis on search incident to arrest? Did that?
He wrote that. It
So
wasn't...
once the judge does that, don't you have an obligation to put that issue in front of him and say, no, under search incident to arrest, we have this case Gant that I believe controls, and give the motion judge the opportunity in the first instance to make that call?
I mean, I don't think there's an obligation. I happen to have done that. But I don't think that in that situation, if the judge sua sponte comes up with an argument that's wrong and just decides the case wrongly, I don't think there's an obligation to point out, there's no obligation to file motions to reconsider. I did happen to file one to put Gantz in front of him, so that gave him the opportunity to correct it if he wanted to.
But I'm confused.
But-
You said you didn't file a motion to reconsider. Of course, we have it at Record 27, and we have his ruling, the judge's ruling on it, but you say you didn't appeal that, and that's not before us. So I'm very confused.
I don't think you need to appeal a denial of a motion to reconsider. The issue that was before the judge was, is this here you have a motion for claiming Fourth Amendment violation, and the judge wrongly denied it. That's before you. The fact that the judge wrongly denied it, and maybe it seems unfair that I didn't give the judge the opportunity to correct it. Well, I did. I wasn't hiding the ball. But that's not what's before you now, because what happened next was the judge then made a ruling on the basis of the automobile exception, but it was in an apartment building. So everything begins to get very messy
Didn't
at
he
that
only
point.
address Gant and the automobile exception because you filed a motion for reconsideration raising that?
Right. I wanted to give him the opportunity
Asked
to
him
correct
to
it.
rule on it.
Yes.
He did. You did not appeal that, but you want us to decide the case based on that.
No, I just want you to decide the case based on the 14th, based on the 4th and 14th Amendment, as it was before him. Honestly,
All right, then let me ask you, as a practical matter.
Yeah.
The two defendants are on the ground. This officer, while awaiting backup, is covering them with a rifle because there's been a report of a gun in the apartment,
Yes.
and there's the backpack. Under your analysis, they could have seized the backpack before they handcuffed the defendants, but that certainly would have put the officer's safety at risk, right?
No, the backpack was in another room out of reach of the defendant, so it wouldn't have put
So
their
they
safety
could
at risk.
never have seized the backpack.
Well, they certainly could have seized the backpack, but they wouldn't have been in danger by doing so at any time.
How did they know? If there's a person calling, watching a Ring video of people in their house with a backpack and a gun, at least that's the report, and literally a minute or minutes later, the officer is there, how does the officer know where the gun is unless he searches it? I mean, isn't there a safety factor involved? Maybe it's in the bag. If it's not in the bag, maybe there's a person in the closet. Maybe it's on the other person. Maybe it's in another room. How is there not some sort of exigency that warrants the officer in ensuring then and there where the gun is or is not?
That's actually covered in Chamel. So this is now old law, going back to 1969, that a search incident to arrest doesn't give you the right to go through the whole house looking for stuff. It just doesn't. and that's settled from 1969. So the issue is always what's within, as of 1969 with Shamel, the issue is what's within the reach of the
Shamel
defendant.
involve a case involving a report of someone with a gun and the police coming as the crime is occurring? I don't think it did.
No, Shamel was a robbery. I think it did involve a gun, but it was, or at least a weapon of some kind, but it was an arrest warrant for the defendant that issued later. So no, it wasn't that case, but Shamel doesn't only apply, Shamel is used to apply to cases from 1969 on to determine the scope of exigency. And the idea of the presence of a gun is considered equivalent to the danger of destruction of evidence, right? It's not like if there's a gun, you have more danger in that context. The exigency is the same.
I'm sorry to interrupt, but you're getting to my question here, which is there's this trilogy of cases that Riley talks about. I'm talking about Riley versus California, 573 U.S. 373. And there the court addressed Gantt. And the court said, in part, the search incident to arrest trilogy concludes with Gantt, which analyzed searches of an arrestee's vehicle. And it talks more about the vehicle context. And then the Supreme Court goes on to say, the United States first proposes that the Gantt standard be imported from the vehicle context. But Gantt relied on circumstances unique to the vehicle context to endorse a search solely for the purpose of gathering evidence. Justice Scalia's Thornton opinion, on which Gantt was based, explained that those unique circumstances are reduced expectation of privacy, heightened law enforcement needs when it comes to motor vehicles. And the U.S. Supreme Court goes on to say, similarly, in the vehicle context, Gantt restricts broad searches resulting from minor crimes such as traffic violations. When I read Riley, and there's some subsequent First Circuit case law, it suggests to me that Gantt is limited to the motor vehicle context. Can you tell me why I won't call it an understanding, but why my pass-through on that might be incorrect?
Let's say, why is it that every circuit to consider it has not limited it, right? And why is it that the First Circuit still hasn't? No, they haven't. They actually, you're thinking about Perez. And in Perez, what the First Circuit held was that in a case where something is being carried, the analogy is not to Gantt, but if the item is being carried, the analogy is to the search of the person. So, and there's actually a circuit split on that issue, whether Gantt should also apply to search of the person, but it's certainly, no one has ever said that if you just have a bag in a room, that Gantt doesn't apply to that. So we would be the First Circuit to do that, and it would create a circuit split. And here's why no one has done that so far.
About the language of Riley I quoted.
Here's why the language of Riley doesn't apply. First of all, again, we're not talking about a situation of carrying, right? We're talking about a situation of something on the ground, so that's a distinguishing factor. And also, the search of a vehicle is, in every context that it's ever been used, the privacy rights are less. So
Gantt relied on circumstances unique to the vehicle context, is what the U.S. Supreme Court said.
Yes, and Gantt did rely on that. And even in that context, where there is a reduction in the scope of privacy rights, even there, it has to be, what they extended it to was the area at the time of the search, not at the time of the arrest. So you're talking about, there's no doubt that the area is restricted to the reach of the defendant. Shamel ended the idea that you can just go through the room because maybe something will vanish, right? And now you're just talking about, the only issue is it at the time of the arrest? Do you measure it? Or is it at the time of the search that you measure it?
What if those are contemporaneous? Because this happened within seconds.
Well, I mean, it happened within seconds, but the search happened in a different room. So it really matters, even though it's not about the time, it's about the geographical scope, because the officers aren't in danger from possible time travel backward, right? They're in danger from reach today, at this moment. So the issue is never timing, the issue is geography.
If we accept what you say, is Figueroa bad law?
Figueroa is actually dicta. Figueroa was decided on consent, and the footnote, I think it's footnote 4, is cited in that. I think there's a lot of dicta in there that I think arguably misstates the federal standard. And I think it's the kind of...
Figaro has been cited by a lot of cases, not just by our court, but by the SJC for a broader proposition, so I'm not sure.
It's a problem. It's a real problem because it directly contradicts Gantt, and you can see, because it says this, it's the search, the timing is going to be at the search, the timing is going to be at the arrest instead of the search. And every circuit so far is agreeing it's the timing of the arrest, it's the timing of the search, not arrest.
And I know this is not your position, but would you agree with me that if Gantt is limited to the motor vehicle context, that Figueroa is still good law? Understanding your position that we would be the first people to say that.
No, because Figueroa doesn't limit. Figueroa makes a broad statement that would apply to cars too.
Well, but we don't
Figueroa
have
doesn't
to-
exempt.
we don't
Figueroa
have to
doesn't
address-
say except for Gantt.
We don't have to address that aspect of Figueroa, because this, as you say, is not a car case.
And
So
also,
I
it's
just want to
dicta.
make sure I understand. Your view of what the First Circuit said is it might have said Gantt is confined to the auto context, but it wasn't dealing specifically with search incident to arrest and whether that is determined as of the time of the arrest or as of the time of the search.
Right, and it also doesn't say Gantt is limited to the car context. In fact, the First Circuit cites Gantt in Worry, which is cited in my papers, which is not a car case, for the broad scope of what the search incident to arrest looks like. So there's an assumption that it applies, and the distinction really is just with all these cases involving physical carrying. If you get someone while they're physically...
Your time is up, but I know I have an additional question. I want to see if the panel has any additional questions. So my question is, if you presume that we can affirm for any ground apparent on the record, why can't we affirm this as inevitable discovery?
Because there's nothing inevitable about this discovery.
Why not?
Because, except for the fact that my client told the officer that it's in the bag.
And that's out, we know that, that's
Right,
out.
but that was the probable cause to search the bag.
But they knew, the police knew that that someone had been seen carrying the bag. The bag was sitting there. The resident wasn't going to claim it. Isn't it inevitable that police would have, if they hadn't searched it incident to arrest, that they would have gone and gotten a warrant? I mean,
No, I think on
we
this-
all agree there's probable cause to search the bag.
Oh, on these facts there were because my client said that, but it's out, right?
No. I'm saying
Yeah.
even apart from your client's statement, was there not probable cause to search the bag?
Not on this record, no, because here's what they didn't establish. One, that it was the same bag that my client carried in.
Okay,
Two, that the owner of the property wasn't asserting his right to the bag, that you wouldn't just go through and search every single thing in the house unless you knew that it was associated with my client.
Oh, but people are ransacking someone's house on video, carrying a gun, and they have a backpack with them. It's reasonable to believe that there is evidence of the crime, perhaps the gun, perhaps stolen items, in that bag.
If the prosecutor had introduced any evidence at all that that bag was the bag, this isn't an empty apartment, this is a place people live, there are bags.
It's a reasonable inference that if the defendant is is told to get out, gets out of the door, lies down at the officer's command in the hallway, and the bag is basically at the threshold of the door, it's a reasonable inference, arguably, that that is the same bag.
Well, reasonable inference doesn't get you past preponderance unless there's some evidence that that was the only bag in the apartment, some evidence that the homeowner didn't claim the bag. I mean, most bags you leave by the door. That's where you use them, right? So in order to get past preponderance on that, the prosecutor would have had to put in some evidence of a reason to believe that this particular bag was associated with my client as opposed to associated with any of the other residents of the apartment at the time, right? This is a lived-in apartment. This is a regular apartment with bags and shoes and all the things, right? So they would have had to put on evidence to meet their preponderance standard, not just, well, there's a bag in an apartment, and the apartment was being robbed. So clearly the bag must belong to the person robbing it. I don't think you can get
We
there.
have to leave it there, Attorney Goldblatt.
Thank you.
And Commonwealth, if you need additional time, we will give that to you as well. Attorney Motherway?
May it please the court, Assistant DA Carmel Motherway, representing the Commonwealth in this matter.
Can you maybe move the microphone closer or speak a little louder? Thank you.
Yes. I just want to address two things at the outset that counsel referenced in the defendant's argument. One is that the evidence showed at the hearing that the book bag or backpack was inside the doorway on the floor between the defendant lying just outside the open door to the apartment and Mr. Verrouet lying just inside the open doorway. And the citation to the transcript for that, the motion to suppress transcript, was volume 1, pages 15 through 25. The second thing that I wish to address.
Well, is that in service of the inevitable discovery argument, or what point does that go to?
It goes to the point that the representation was made that the bag was not in the vicinity of Mr. Soto such that it posed danger, a danger that the officer needed to search the bag.
Once he was handcuffed,
Right.
did whatever was in the bag still pose a danger?
Yes, Your Honor, it did. I have cited the FBI and DOJ statistics. They actually compile statistics of law enforcement officers that were shot.
Well, we may or
by
may not
handcuff.
agree. I'm sorry to interrupt. We may or may not agree with
Right.
what's in those statistics, but in terms of case law, what about Gantt?
That one,
If under a strict reading of Gantt, are the police required to obtain a search warrant before searching that bag?
no, we have Commonwealth versus Figueroa that specifically states that one can search it prior, at the time of arrest, after the arrest. And we also have 276,
But a strict reading,
Section 4.
I'm sorry to interrupt, but a strict reading of Gantt would arguably would contradict that. And if so, U.S. Supreme Court case law is going to trump a Massachusetts statute or an SJC case. In other words, if Gantt offers more protection to the individual, then that trumps Figueroa. So again, my question is, under a strict reading of Gantt, do the police need a warrant before searching that bag? Putting aside inevitable discovery for now.
I don't believe so, Your Honor, because Gantt was decided in the context of an automobile where the police were exploiting this opportunity, having stopped an automobile and extending the search far beyond its rightful purview. So I think that counsel introduced, for the defendant, introduced that, and it was a red herring. And I thought that the tenor of Judge Kalman's note was expository, like this is what, Gantt stands for, and then he took out of it the one element that was important relating to search and seizure in the context.
How is the fact that Gantt arose in an automobile context, how does that make the particular rationale of Gantt about when you determine the scope of a search incident to arrest, whether it's at the time of arrest or the time of the search, how is that particular rationale confined to the auto context? I mean, isn't the idea that once the defendant or the suspect is away from a particular area or a particular object, once it's no longer within his reach, what's the safety rationale or any other rationale for searching that item, whether it's 10 feet away and out of his reach because he's handcuffed or 100 feet away? What's the rationale? How is it reasonable?
I'm having a little difficulty, Your Honor, with several questions.
Okay, sorry. Explain to me the basis of the Figueroa ruling, that the police can lock up, can secure a suspect or move a suspect to another area, and then go back and search the area where he was at the time of arrest on the theory that, he might still grab the gun in the backpack.
I believe it
or
was,
destroy the drugs in the backpack.
I believe it was stated in Figueroa that the reasoning was, and I could be mistaken as to my citation, but the reasoning was that it would subject officers to undue safety, exposure to undue harm if we were to insist.
Well, doesn't that leave it to the officer's choice? I mean,
Yes.
they can either search exactly where the defendant is at the time they arrest him, and anything within the wingspan or the lunge area, or if they take him somewhere else, then they can search that wingspan area, lunge area. But what justifies them taking him somewhere else or securing him and then going back to the first place?
Well, the defendant here was exiting the apartment, and he was told to, at gunpoint, to get down on the ground, pretty much where he got to. He wasn't taken away from the premises.
Okay, and then he was handcuffed. But once he
Yes.
was handcuffed, he couldn't reach the backpack, even if it was only, and reach in for a gun, even if it was only 5 feet away or 10 feet away.
Your Honor, I think that's what the court's perspective from, in the circumstances we find ourselves as attorneys. I think that the court recognized that there is the possibility and potential for even somebody handcuffed to cause injury. And the gun had not been found or seen. It was,
So if he'd been taken to another room or down to the cruiser, handcuffed, could the police then go back upstairs and search the backpack?
Your Honor, under Massachusetts case law, yes, they can.
And how is that reasonable?
It's a search pursuant to arrest.
Could they search, let's say they walk him down the hall, down the elevator, through some area where there are a lot of places to hide things, put him in the cruiser, and then they do the search incident to arrest. Can they search everywhere that he's been from the time he was seized to the time he's in the cruiser on the ground that he could have reached into those areas and grabbed a gun or destroyed some evidence?
Well, the legislature has enacted Chapter 276, Section 1, in which it says a search incident to an arrest may be made only for the purposes of seizing fruits, instrumentalities, contraband, and other evidence of the crime for which the arrest has been made in order to prevent its destruction or concealment, and removing any weapons that the arrestee might use to resist arrest or effect his escape. This call came in that one of the participants was armed, and when the tenant who was calling 911, there was also something in 276 Section 1, which the language, if one parses it, other evidence of the crime for which the arrest has been made. It doesn't say for which the arrest is being made. It says has been made. So that seems to contemplate that there may well be grounds, statutory grounds for the police officers to search and seize after.
And would that interpretation of the statute control over the Supreme Court's interpretation of the Fourth Amendment?
Well, the Supreme Court's interpretation of the Fourth Amendment, Your Honor, I had looked at that more with whether or not there was a reasonable expectation of privacy here.
Well, I'm referring
But-
specifically to Gant and what Gant says about the search incident to arrest.
Your Honor, I would have to say that the way I read that and the language that the court used, it seemed to me that it was addressing the former exploitation of, by the police, of automobile searches incident to an automobile stop. And I think that...
Do you know, your defense counsel has said that every circuit to confront the question has ruled that Gant's view of search incident to arrest, that is, that the scope of the search is determined at the time of the search, not the arrest, that aspect of Gant is not limited to the automobile context. Do you know of any case where a court has confronted that issue and said, yes, Gant, that aspect of Gant is limited to the automobile context, whether it's a circuit or a U.S. District Court or any state court?
Well, on the facts here, this search was incident to arrest, and
That's not my question.
Yeah.
I'm asking whether any other case, any other decision you know of, has interpreted Gantt the way you're asking us to interpret it, which is that what it says about search incident to arrest being determined at the time of the search, that's only in the auto context. In an arrest in an apartment, you can take the defendant to another room, handcuff him, and then you can go back to the place where he was arrested and search that.
I haven't researched that, Your Honor. I
Well, that's kind
just
of a
have a
critical-
general knowledge.
That's kind of a critical question in the case, isn't it?
Well, my understanding was that this was a search incident to arrest under 276, Section 1, and the case law...
But you've got to
in Massachusetts-
agree that 276, Section 1 does not trump
I understand that,
the
Your
Fourth Amendment.
Honor. I understand that, Your
So
Honor.
let me ask you this. So Gantt states that it authorizes police to search a vehicle only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search. But Gantt added, and I'm reading from Riley versus California, an independent exception for a warrantless search, in that case of a vehicle's passenger compartment, when it is, quote, reasonable to believe evidence relevant to the crime of arrest might be found in the vehicle. Would that exception apply here?
Well, it might be
Is it reasonable to believe that
that
evidence of the crime of arrest, here, people engaged in an armed robbery or a breaking and entering, is it reasonable to believe that evidence relevant to that crime might be found in that bag, right there?
On the facts here, yes, Your Honor, because they were seen on, it was related by a reliable informant, not informant, but individual who was apparently watching from the ring camera as though he were present, that they were carrying a bag and one had a gun. So I do believe that that would encompass the facts here.
Are there any cases post-Riley from the U.S. Supreme Court which explain what they meant by that independent exception?
Your Honor, I didn't research that. I can't speculate.
Okay.
Going to this case, I believe this court can uphold it, first of all, on the fact that the defendant raised an issue that was not before the judge and did not alert the judge to that and give him the opportunity at the time of the hearing.
Well, can I ask you, in your brief at page 18, you cite to Texero Furtado for the proposition that we shouldn't consider something raised in the motion to reconsider, but that case dealt with the Commonwealth
Right.
arguing an alternative ground. Does that apply with equal force to the defendant?
I did note that, and I was unable to find a case that said it applies.
At a minimum, wouldn't we have to look at it for substantial risk anyway?
Yes, Your Honor. Yes, Your Honor. I did consider, when I read defendant's reply brief, about the reasonableness of the whole situation here in terms of Mr. Soto's argument. And I was looking at Figueroa for the proposition that one had to have, it was Delgado Rivera, I'm sorry, a reasonable expectation of privacy. And what we have here is essentially a burglar plying his trade, and that the issue before the court would be he has standing because he has been charged or was charged with possession of the object, the heroin. But Delgado Rivera is opening an interesting area in terms of standing is being merged with a reasonable expectation of privacy. And here we have an individual who's basically, as I said, the proverbial burglar plying his trade, a remedy in this matter.
I know we went over with sister counsel. Do you want to say anything in wrap-up, or do you want us to take the rest of your argument on your brief?
I would ask that you do take my argument on brief and that you uphold Judge Cowlin's decision denying the defendant's motion to suppress.
Thank you both. The case is under advisement. Very interesting case, very helpful arguments. Thank you both. Apologize in advance if I mispronounce the next name. Our next case is Commonwealth versus John Fontes, 23P829. Good morning.
Good morning, Your Honors. My name is John Maddox for the defendant, John Fontes. The Commonwealth exercised a peremptory challenge as to a person of color who was a Haitian national, juror number 22, and gave as the reason juror number 22's demeanor while answering questions from the judge concerning English language proficiency. The judge accepted that reason. The judge also ruled that the objection to the peremptory challenge was untimely. It did occur right at the end of impanelment, before the veneer was dismissed and before the jury was sworn in. I'd point to, and the defense attorney stated that he made the objection when he noticed that there was the basis for the objection. I would cite the notes to the Massachusetts Guide to Evidence for Section 1116B as to timing, as to objections to peremptory challenges. It says, to preserve the issue of an improper peremptory challenge for appellate review, the objection to the peremptory challenge must be made as soon as the basis for the objection is apparent.
How wasn't it apparent at the time that of the individual voir dire of juror 22?
It could have been, yes, Your Honor, under an objective standard. I'm suggesting that this subjectively was made when it was apparent to the defense attorney. So I'm suggesting that that the preserved error standard of structural error applies, although before getting to structural error, there has to be a review of abuse of discretion as to the judge's weighing of the factors for the peremptory challenge. So it's abuse of discretion, ultimately heading for structural error. The alternative, and I forgot to put this in my brief, and I apologize to the panel, is that if there is a waiver, if the panel decides that this is unpreserved, then the alternative standard would be substantial risk of a standard of review, a miscarriage of justice, I mean, rather than an outright waiver altogether. And that may be where we're heading on this. In regard to prejudice beyond abuse of discretion, under that standard of review, I would suggest that there's prejudice where Mr. Fontes, a person of color himself, took the witness stand and gave a somewhat different version of the events than the police officer did, and he might have had a more receptive audience from juror number 22, a person of color.
So can I ask you, it's so hard, right? Because we're looking at a cold transcript, and my sense of the challenge had more to do about English proficiency than anything else. And the judge asked the Commonwealth for an explanation, the Commonwealth gave an explanation, and I think the judge accepted that, which I would think would be, under at least Commonwealth versus Curtis, an implicit finding that it was not an improper basis. We don't have anything other than a cold transcript, so we don't know what the juror sounded like, but the juror's demeanor, the way the jury answered questions, that's a credibility determination within the purview of the trial judge. And while it would have been helpful for the judge to have said more for appellate purposes, can't we uphold this based on the judge's implicit finding, based on the prosecutor's representation that this was about communication?
I don't believe so, Your Honor.
Why?
Okay. Maldonado case on page 465 says that looks or gestures by themselves cannot be an adequate reason for peremptory challenge. Here we have demeanor. We're tying it to a specific concern, English language ability. That looks like it meets that standard. I'm suggesting it does not, because here we don't actually have a concern. The concern is about a possible English language problem, something that does not appear from the record. It's only...
Most of the answers were one word, right?
Yes, Your
no,
Honor.
yes, no, okay.
They were one-word answers. The judge asked, is your English pretty good? Yeah. You didn't have any trouble hearing any of my questions or understanding any of them? No. If I picked you as a juror, can you listen carefully to all the evidence and discuss it with your fellow jurors? Yes. Any doubts? No. So on the papers, there does not appear to be an English language problem. I'd contrast that from the Valentin case cited in my brief, where the person stated expressly, I have difficulty understanding English. It's different, I'm suggesting, than what's the name of the case? Gardner case, where the juror said, I've been in this country for 20 years. I communicate on my job. The strong inference there is that he doesn't have an English language problem. Here, there's the possibility of an English language problem, but I'm suggesting that that is speculative on this record. Another case I've cited in my brief is the Nunez case, demeanor plus arrest and prosecution. Not possible arrest, arrest. It's a real thing. So here we have demeanor, possible English language problem, not English language problem. So I'm suggesting that it's less than the specific concern that needs to be established to get past Maldonado, page 465, where demeanor alone, looks and gestures, is insufficient to establish adequacy. That's my argument.
Can we go back to the timeliness?
Certainly.
So my understanding is the standard is, the objection should be made when the basis of the objection becomes apparent. The basis of the objection here was the prosecutor is challenging a person of color, correct? It's a race-based challenge is the allegation. That was apparent at the exact time the prosecutor exercised the peremptory challenge, correct?
Under an objective standard, yes, Your Honor.
Okay. And the only thing that changed, because then additional jurors are impaneled, I think additional jurors are excused. The only thing that changed prior to defense counsel making this objection is the judge told defense counsel, you're out of peremptory challenges.
Yes, Your Honor.
And then the defense counsel comes back and says, well, you know what? I want to challenge now, I want to object to the prosecutor's challenge of that juror, and I'm alleging it's race-based. Didn't the trial judge have the ability, number one, it strikes me as untimely, but number two, didn't the judge have a basis to reject that at that point as being pretextual on the part of defense counsel?
Boy. Well, defense counsel's obligation at that point is to offer something that suggests a discriminatory intent. That's his obligation. And that's a minimal showing, if not a nominal showing. I believe it's the Sanchez case.
Yeah, I agree. So why the delay? Why the wait? Again, the only thing that changed was the judge said you're out of peremptory challenges now.
It depends on whether you view it as an objective standard or a subjective standard. Subjectively, this is when the defense attorney made his objection.
It's your last
when
chance
he realized
last chance to preserve the record, sort of, right?
Yes.
Okay.
Plus, we have a full record. I mean, the Batson-Sora's analysis is established on the record. We need a little help from Rule 83 reconstruction of some of the verbiage, but we have a full record here. It's not like I'm making this argument and there's nothing on the record and you tell me, well, if you have a problem with that, file a motion for a new trial. That's not what we're doing here.
But isn't the point of making a timely objection is so that the judge can make a ruling and the juror stays on the panel, presumably? Here, for all we know, the juror's 10 miles, the juror's gone.
The jurors, no,
so-
Your Honor, the juror is not gone. The defense attorney said, I can see the juror in the veneer. So the juror is there. The veneer has not been dismissed.
So are you suggesting that they should have recalled the juror and done additional voir dire?
Yes, Your Honor.
Did
They
the
asked
defense counsel ask for that?
Thank you.
No, Your Honor, he did not. However, I would point out that this is a burden-shifting scheme. The burden to make that, to present that, to produce that and prove that is on the Commonwealth, not Mr. Fontes at that point.
So you stipulated in the course of reconstructing the record that the judge found that the reason given was both adequate and genuine.
Yes, Your Honor.
Are you suggesting that we should disagree with that?
As to adequacy, I'm suggesting that as to adequacy, that the record remains speculative.
How can we do that? I mean, going back to Justice Blake's initial question, we weren't there. The judge was there. The judge accepted that the Commonwealth thought this juror might have some issues understanding English. How are we supposed to say that's an abuse of discretion? It's hard.
I'm suggesting that falls into the realm of demeanor alone, rather than demeanor coupled to a specific concern. I'm suggesting it's almost there. It's like running a race and falling down right before the finish line. It's not quite there. You don't quite have a specific concern. You have a possible specific concern, but to get past Maldonado, page 465, you have to have something that's more than just demeanor. So the judge's demeanor, he can.
Is it demeanor when the Commonwealth says the ADA is concerned about the juror's demeanor or tone of voice? In other words, that it appeared ambivalent in answering the questions about English proficiency.
I believe that's demeanor.
And that's not just an expression on a face.
It's tone of voice, something of that nature. It's the same thing. You have to have more than that.
Well, but, you know, while we sit here in the courtroom, and if I say to Justice Neyman, did you understand that? And he says, yes, or he says, yeah. Those are different answers to me, right?
Sure.
And that's to the point that I was trying to make, and Justice Sachs, the judge was in the position to decide, was it a yes or a yeah?
Yes, Your Honor.
How do we do that? We can't.
No, you cannot. But what you can do is require that when demeanor, it's a demeanor plus something. It's not just demeanor. The judge is in a great position.
Isn't the plus the answer and the tone of the answer, the context of you think that's all one thing?
I'll go back to Nunes. You have demeanor plus the arrest. You don't have a possible arrest. You have an arrest. That's what makes it more than just demeanor alone. Demeanor alone is insufficient. Demeanor, I would suggest that demeanor plus a possible arrest is insufficient.
But the ADA didn't just say his demeanor, Your Honor. The ADA tied it to a specific factor that's clearly relevant.
She had a specific concern, but I'm suggesting that this record doesn't make that out in sufficient detail.
It doesn't make out demeanor plus communication here?
I don't believe so, Your Honor. You need something to suggest that there is a legitimate concern there, not just hey, this person is from a different country, maybe they can't speak English. You have to have something more than that. That's my argument.
I don't want you to change your course or path, but I'm noticing 2 minutes and we didn't get to your second issue. Do you want to address impairment?
I prefer to rely on my brief for that, Your Honor. Thank you.
No, well briefed. Thank you.
Thank you so much. Attorney Marvell?
Thank you. Good morning. If it may please the court, Elizabeth Mello Marvell on behalf of the Commonwealth. What we're really talking about here is whether or not we trust a judge to make an assessment based on what they see in front of them.
Right, so in the perfect world, the judge would have said, I have concerns about the juror's ability to communicate and comprehend what's happening. We know that didn't happen.
Correct.
So what we have is the Commonwealth saying, here's my reason, and the judge saying, I accept it. And as I read your brief, you say, that's enough.
I do, Your Honor, and granted, it would have been great, as you say, in the perfect world, to have a more developed record, which possibly could have happened if the objection had been made in a timely manner, because the juror would have still been standing there in front of the judge, the objection would have been raised, the judge could have inquired further, perhaps could have had the asked questions in a way that the individual would have had to use more than just a one-word yes, no, yes. At one point, the juror says yes, the judge says yes, yes, and they're going back and forth. So perhaps it wasn't as clear as reading YES on a piece of paper. Again, this is why we have, the judge is a fact finder in this arena as far as how a juror reacts to the questions, how they phrase it. As Your Honor pointed out, there's a yes, yes, yes. All of those are going to look like YES, YES, YES on the paper, but those are very different things. It's the same thing that we do with a jury when we say, you can observe the witness's demeanor, their expressions. It's not just what they say, it's how they say it. It's the reason why people have to testify in person. It's all of that same factor. And if
So to counsel's point about Maldonado, you say that, well, what do you say the plus is here?
I say the plus is it's more than just, do you understand? Yes. It's more than that. The judge is watching how the person answered it and heard the prosecutors. If the judge was not satisfied with the prosecutor's explanation after their own observations and interaction with the juror, they certainly could have asked more questions. Now, we do run into a problem with the idea that if the objection had been made at that time and the judge made further inquiry and then was not satisfied, did not find it to be an adequate or genuine explanation, they could have said, don't agree with you, the juror is seated, and then they would have moved on. Instead, here what you have happen is I think we're 9 jurors later, the veneer is already sat. What would have happened? The judge perhaps would have brought them back up. There would have been further inquiry, and then what, you would have pulled someone else off of the jury? Like, it creates just this problem that the judge would have had to, uncertain how that would have played out. But the point is, it wasn't made in a timely manner. It was made later on, and that whole discussion was then that whole conversation about was it adequate was happening many jurors later after they were already others that were seated. So I think we do have a timeliness issue. It should have been raised at that particular point in time. And then putting that aside, the question is whether or not Batson Soares was followed, the protocol, and the Commonwealth's position, it was. An explanation was offered, the judge accepted it as genuine, and the defendant doesn't challenge whether or not it was genuine initially, didn't challenge whether or not it was adequate, but is now saying that the judge's determination that it was adequate was error. But it's the Commonwealth's position that they were in the best position to assess that, and that they did, and that it shouldn't be disturbed on this record where it's not clear that that was an abuse of discretion.
May I ask about page 27 of your brief in discussing Maldonado, in a parenthetical, you include, you say, by responding, I accept it, the trial judge indicated her specific finding that the proffered explanation was both adequate and genuine. That's page 27 of your brief.
Yes.
I couldn't find that or anything like it in Maldonado, and it seems contrary to the overall tone of Maldonado, which is that there needs to be a separate finding and specific finding on each of those issues. So I just want to make sure, am I looking at the wrong copy of Maldonado? Was it changed after publication?
My understanding was, the way I read that was the judge has to accept the explanation as it's a both. So by saying I accept it, they're saying that the prosecutor's explanation is meeting both prongs. That was how I interpreted that.
It's not really an issue here because the parties have stipulated that the judge found the explanation was both adequate and genuine. We're not just faced with a situation where the judge said, I accept it, and we have to figure out what that means. But my question is really about whether Maldonado stands for this proposition, apart from its application to this case. Whether it's enough to say, I accept it, or the judge doesn't have to say it's both adequate and genuine.
I think if the judge is accepting it and they say, I accept it, everyone knows because it's clear that it has to be both the explanation has to be both adequate and genuine. So I think if the judge is saying, I accept it, I think they're implying that. I think if they're not accepting it, and I think then it becomes more an issue of on which area are you not accepting. So I don't mean to misconstrue that, but that was my interpretation of it.
Well, I read that following the Curtis decision, which was a much older decision, that when the judge says, I accept it, that's an implicit finding.
It's not that old.
Right, it's not that old, 1997, but as compared to Maldonado. So is that what you're saying, as between those two cases, when the prosecutor makes their proffer and the judge says, I accept it, that conclusion is then that the judge accepts or makes an implicit finding as to both prongs? Is that what you're saying?
Yes, that is what I'm saying, that I don't think it's necessary for the judge, I don't think it's required that the judge say, I accept your explanation as adequate. I accept it as, I don't know that they have to say that.
Let me read you from Maldonado.
I apologize.
It is imperative that the record explicitly contain the judge's separate findings as to both adequacy and genuineness, and, if necessary, an explanation of those findings. So it may not have an impact on this case because there's a stipulation. I would just suggest you go back and look at Maldonado and maybe revise the parenthetical for future cases.
I do appreciate that. Thank you.
Thank you.
If there are no further questions, the Commonwealth would rest on its brief.
Let me just
No,
check.
the only thing I would say is I commend Attorney Maddox and the DA's office for their use of Appellate Rule 8E and the stipulation in reconstructing the record. Very well done by both parties, and we appreciate it.
Thank you.
We will take the rest of your arguments on your brief. Counsel, thank you both. The case is under advisement.
Thank you.
We'll have to get them on a panel for how to reconstruct the record. Okay, we're going to hear one more case before the morning recess, and that is docket number 23P336, Commonwealth versus Derek Reyes. Good morning. Good morning. Attorney DePalma, take your time whenever you're ready.
Good morning, Your Honors. May it please the Court. My name is Valerie DePalma, and I represent the defendant appellant, Derek Reyes. Our first argument is that the evidence was legally insufficient to support Mr. Reyes' convictions of unlawful possession of a firearm without a license and unlawful possession of ammunition without a firearm identification card. In this case, there was no evidence of that Mr. Reyes actually possessed the weapon. The only...
Maybe no direct evidence, but
Constructive.
lots of circumstantial evidence, wasn't there?
Well, I'm sorry,
No one said, I saw the guy who was arrested with the gun, but someone came to the door with a gun, left the gun and the cell phone from inside the house were found right close together, close to where he was arrested.
Well, they were found 72 feet from where Mr. Reyes was arrested.
Okay,
So
but you, just to be clear, you agree there's some circumstantial evidence that he had a gun?
Well, there's circumstantial evidence, but I wouldn't, I contest the sufficiency of the circumstantial evidence.
Man wearing a devil mask, sounds like the beginning of a bad joke, but man wearing a devil mask
Yes.
breaks into a home, strikes someone with a handgun, is then found by the police minutes later, I don't know, a half mile walking down the road, a guy with a devil mask in his backpack or in his satchel or whatever it is, and is arrested, and depending on whose testimony you believe, either 72 feet from there or 5 to 7 yards, there's a gun found there. Isn't that circumstantial evidence that rises to the level of meeting the Lattimore standard?
Well, there was also, the evidence also was that the gun was tucked beneath the tree so that,
We
you
can
know,
judge the photo for ourselves.
okay, okay. And that the area where it was located was also accessible to other people. It was not a place where only Mr. Reyes could have accessed it. I pointed to the other factors that suggest that, that were present in cases that are not present here. In addition, the evidence was insufficient to establish that Mr. Reyes knew that the gun was loaded. In this case, the ammunition in question was the ammunition found inside the gun. Again, it was found under a tree, and the magazine was inserted into the handle so that it was not visible on its, that
What
whether.
about the Mitchell case that basically says people who carry loaded guns know they're loaded?
Well, I think it's a little bit of a tautology. I mean, you can, yeah, I know of the cases that say, if someone points a gun at you, you can assume they know, that it's loaded because they're threatening you with it, which I don't know if that.
So how would you ever prove, out of curiosity, that someone knew a gun is loaded unless they admitted to it, or unless their fingerprint was found on it, or their DNA? How could you ever prove that crime?
I mean, yes, it would be a much harder case. Perhaps the person had other evidence on themselves connecting them to the weapon. I mean, yeah, on its face, absent, other evidence that would connect the person to the gun, including their statements or, if they were carrying matching ammunition but yes, and of course, the defendant's going to use that, right, to your fullest advantage because, yes, you cannot, intent, knowledge are not elements that are easily provable by direct evidence. And so, again, here we have a gun under a tree, tucked, that was magazine inserted, and that, on those facts, there's nothing that is, in plain view which would suggest the gun was loaded.
Can I ask you about the Guardado issue? The Guardado issue, the licensure
Yes,
issue?
yes.
Why doesn't Bookman control here? There was evidence that he wasn't licensed. It's true they didn't get the instruction, but I think the SJC said within the last year or so that that's harmless beyond a reasonable doubt.
Yes, I read the case, I cited it, and my argument is that there was some challenge to the officer's testimony. I mean, again, it wasn't, and again, my opponent argues that, counsel's or, the defendant's arguing it was inadmissible hearsay and they didn't make a hearsay objection, and my response is, but at the time, they didn't have to prove it. It's sort of the same kind of where we excused defendants from making a Guardado objection at that particular time he was tried. So I think it's fair to argue that we shouldn't have also insisted that they make objections. I mean, it was certainly, but my point was that, yes, they did admit some evidence. This is a case where the DA, I think saw
The writing was on the
the wall, right. But, of course, it hasn't been worked out, as far as I know, what's going to be sufficient.
What about
The circumstances.
This was tried after Bruin, but before Guardado.
Yes, it was in the.
What about the hearsay exception for diligent search failed to disclose a public record or statement is admissible to prove their record doesn't exist? So in other words, he says, I checked, he didn't have a license to carry, he didn't have an FID card. Isn't that within that hearsay exception?
I think it would be if he had, first explained how he conducted the check. You know, there was very little evidence concerning, was he trained to do, was he qualified? You know, and at that point, I mean, had he been, you know, had he testified to his qualifications to conduct these kind of license checks, and that he conducted a diligent search, you know, maybe more questions about that, what they consist of, then perhaps there might be a basis to argue that it comes in within that, the absence of record exception. And here I'm, you know, the defendant is trying to, in any way possible, distinguish Bookman, which conceitedly is hard to distinguish under these facts, which was why I was going to turn directly to my point 3, which is the inadmissible, the improper admission of the statements of identification by a non-testifying witness.
Can I just be clear at the outset on that? Is the statement you object to, quote, she told me the intruder's name was Derek?
Yeah,
Unquote. Is that the only one? That's
our position is that the testimony by the victim who did appear concerning the non-testifying victim's statements identifying the intruder as Mr. Reyes was improper. It was a violation of the rule under Herndon.
Well, but we need to know which specific statements in the testimony.
Okay, I'm sorry, let me just turn to
page,
my brief. I set them out. I mean, there were several.
Looking at page 32 of your brief.
Yes.
At the bottom, you say the ADA could have limited the examination to Berrubi's request not to disclose her familiarity with the intruder to avoid revealing that she had bought drugs from him and owed him money. Mm-hmm. So that appears to be an acknowledgement that that question would have been permissible, and what you object to is that the male victim saying, well, my girlfriend told me the intruder's name was Derek.
Yeah, and not only that, the intruder told me, at one point he says that it was, she had previous dealings with the defendant, and that's on page 31 of my brief. It's at volume 2 at pages 192, 183. So
how, without a motion for new trial, you didn't file a motion for new trial
in this
case. So without a motion for new trial, how do we know that this wasn't a strategic choice?
Because defense counsel said in his opening statement that there will be no testimony identifying my client as the intruder.
Right, but perhaps he changed his mind as the trial went along. I mean, there was a not guilty on the armed home invasion and the assault and battery with a dangerous weapon.
Yes.
And it seems to me the jury could have believed that this is someone whom Berube knew, and therefore we're not going to credit the testimony that this is some stranger conducting an armed home invasion, but rather it's someone they knew, and this was the roots of a drug deal gone bad or a debt being paid. And that's why the only conviction was for possession of a firearm.
True. I mean, I think that was the argument during the closing, and you know, he argued, you know, my client is not the guy, and that, you know, Mr. Reyes had only been present in the vicinity where the gun was found, that, you know, the victims had fabricated.
But I think in the face of the mountain of evidence that suggested that this was the person, including the devil mask being found on his person, him being near the place, the gun being near him, that's perhaps not the strongest argument he had to go with at trial, and instead went with the argument, or at least went with the evidence of, yeah, these people knew each other. So this wasn't a home invasion. This wasn't, you know, an assault and battery. Again, how do we know without a motion for new trial without an affidavit from trial counsel?
Well, because I didn't raise this, I mean, I'm raising it strictly as a substantial risk of a miscarriage of justice, rather than a claim of ineffective assistance. And because of the nature of the verdicts in this case, which were inconsistent, I felt that, you know, in my strategic view that this was a better vehicle for this claim because of that. So
Can you explain how it's a prior statement of identification, though?
it's not, I mean, statements of identification come in few different colors. One is the police had performed identification procedures, which did not occur here.
Right.
This was more of a statement of identification based on prior familiarity, such that, you know, presumably, if they had, if the police had investigated, well, and part, of course, was the delayed disclosure of the statement that the intruder yelled the female victim's name. We would know the nature of that familiarity a little better, and presumably the prosecution would have argued, we don't need to do a hearing about identification vis-a-vis the female victim because she knows it.
All right, but on cross of the male witness, right? He testifies on cross that your client called out Berrubi's name as he followed her upstairs, but that neither he nor Berrubi initially told this to the police. That came out on cross, right?
Yes.
And it's your view that that then did not open the door to the prosecutor's ability to rehabilitate, I don't know if it's pronounced Muelo or Muelo. You say that that's improper. She couldn't rehabilitate him with.
I say that the prosecutor could and was entitled to, but she could have done it without the identification.
Everything but the name.
Yes.
So when we talk about substantial risk, where he said on cross-examination, she told me she knew who he was, and she'd had prior dealings with him. She bought drugs from him and owed him a debt.
Yes.
So does going further on redirect and saying, she told me his name was Derek, does that really tip the balance into substantial risk area? I mean, you don't contest that he was entitled to say, she told me she recognized him, she knew who he was, and she'd bought drugs from him and owed him money.
That it should have been limited to those statements.
But where that was already in, how much of an extra difference did it make? How much of a difference for the jury to hear, yeah, she said his name was Derek?
I think it makes a huge difference. It's a statement that.
Would the trial have come out differently?
Well, I think given that the only other evidence of identification was circumstantial, this is a direct statement of identification, and the defense was, it wasn't him. Statements that that's the guy are powerful. I mean, and of course, and this is coming in through as hearsay. It can't be contested. It can't be cross-examined. Can't be confronted. I didn't raise the Confrontation Clause claim. I just stuck with the hearsay.
We're going to have your final thought because we're going to need to wrap it up.
Okay. And so in closing, we ask this court to reverse Mr. Reyes' convictions and or remand for a new trial. And thank you very much.
Thank you, counsel. Attorney Borges?
Good morning. May it please the court, Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the defendant's conviction. Because the evidence suggested that the defendant actually possessed the gun at the time he entered the victim's house and beat him with it, but no longer physically possessed it at the time it was found, the Commonwealth could sustain its burden of proof by proving actual or constructive possession, and it's the Commonwealth's position that it provided sufficient evidence to support the defendant's conviction of unlawful possession of a firearm and ammunition. Are there any questions on the first issue? I know we kind of discussed actual versus constructive.
I don't see any right now, but I can't promise you they won't develop.
All right. Then just briefly discussing the evidence that was provided at trial regarding the actual possession of a gun.
Actually, two things. One, I'm going to ask you to slow down just a little bit.
Sure.
It's okay. I can't think as quickly as you can speak. So the second thing is going to the issue of the hearsay, admission of the alleged hearsay testimony. What is the basis for the admission of that testimony?
Which hearsay evidence are you talking about?
Testimony from, about the statement of identification, the statement to the effect of, Mr. Mello or Mulow's testimony about what Berube had said to him.
Sure. So that statement, which was not objected to, and it was elicited on redirect.
You said it was admissible to rehabilitate, I think, the witness.
Correct.
What case stands for the proposition that you can rehabilitate a witness through inadmissible hearsay, otherwise inadmissible hearsay?
So the case that the Commonwealth relied on for that proposition was the Holiday case that was cited in the Commonwealth's
Will they
brief.
state the proposition as I just stated it? I don't think so.
Not word for word. That's more proper for the prosecutor to rehabilitate the witness who's been impeached about a failure to share information sooner, even when the explanation would, absent the defendant's opening the issue, would be more prejudicial than probative.
So go back to my question. What case stands for the proposition that it is appropriate to rehabilitate a witness by admitting otherwise inadmissible hearsay?
Off the top of my head, I don't have one.
I think with a lot of research, you're not going to find one that says that. That's just a guess on my part. but-
Sure.
Were the statements of Berube admitted for their truth?
No, they were admitted to in the process of rehabilitating the witness who had been previously questioned about the statements that weren't initially disclosed to the police and why there was that delay. And as previously discussed during the defendant's argument, the statement of concern is really just the name, just his name was Derek. And the name alone, as discussed earlier, did not tip the scale, creating the substantial risk that we have to examine if there was an error, whether it did create a substantial risk, the name alone.
Let me ask you about that, because you cite at page 27, Commonwealth versus Arrington, which is a 1984 case, so I can't say if that's old or not, because Justice Neyman might object. But in that case, the parenthetical says that the statement was admissible not to prove the fact asserted, but basically because the statement was made. So is it your view that it didn't matter, it wasn't admitted to prove that Derek was in fact the intruder?
Correct, yes, it was, that's not why it was admitted. It was just admitted in the context of explaining why there was that delay. And it would be the Commonwealth's position that even if he hadn't have said his name was Derek and he just stopped at she knew him from prior dealings, she had purchased drugs, she owed him money, their circumstantial evidence was still sufficient to place the defendant as the person who had threatened assault and assaulted the victim with the gun, where he was found in close vicinity to the house late at night alone with a distinctive devil's mask and a firearm that matched the defendant's description, the victim's description of the gun that he was assaulted with, which was found next to Berube's cell phone under the tree.
Can I switch you to the loaded firearm piece, the ammunition question, and your citation to Mitchell? So you say it's a general principle of law that people that have loaded firearms know they're loaded, and therefore we can infer that Reyes knew the gun was loaded.
Correct. Correct, yeah, because, I mean, especially given the facts of this case where, and I think they are pretty on par with the cases cited in the Commonwealth's brief, Mitchell, Santos, I believe Resendez also, the facts led to the inference that this was the defendant was assaulting the victim for whatever reason, whatever purpose may be, and the assumption that he would show up with this gun, point it in his face, hit him with it, say, I'm going to shoot you, get on the ground, an assumption that he didn't know whether it was loaded would, I think, fly in the face of common sense.
We have lots of cases where people rob people with what the victim thinks is a gun, but it's not.
But I think where the standard is going to whether the defendant knew it was loaded, the inference stands that they know, even in that case where the victim might think it's not a real gun, the defendant knows. It's on the defendant's knowledge.
And it's in the light most favorable to you.
Correct.
So going to the licensure issue, was the statement by Finicom that he checked the records and he didn't find licensure, is that hearsay?
I believe the testimony was that he looked up, I think it was the registry of, I don't remember the exact name.
Some registry that
Right, some
none of us
registry.
has ever heard of.
Right. He used that, and where we don't, I guess he could have elaborated whether he spoke to someone or whether it was an online database, but regardless, I don't believe it was hearsay where he was directly testifying to him doing the research and he found there was no firearm, there was no LTC, and where it wasn't objected to and his credibility wasn't in question, as discussed. It's the Commonwealth's position that Bookman is controlling in this issue. Are there any further questions?
I don't see any. We will be happy to take the rest of your argument on your brief.
Great, thank you.
Thank you very much. The case is under advisement. We are going to take about a 10 or 15-minute recess, and when we return, we will hear the final two cases on today's list.
All rise.
Next case.
Court is in session. Please be seated.
It's still morning. Good morning. So the next case on our list is partially impounded. So no using the party's names or the child's name, okay? And I'm not sure if everyone was here when we started this morning, so I'll just remind everyone for the next two cases that each side is permitted 15 minutes of argument, and there is no rebuttal. So after we hear from Mr. Curhan, sir, we'll hear from you, and that will be the end of the proceeding, and then we take the case under advisement. So with that, the next case is 23P974, D.A-B versus A.A.B. Counsel, good morning.
Good morning. May it please the court, Dana Curhan for the mother in this case. We contend that the trial court erred in both issuing and extending the 209A abuse prevention order. There simply was nothing establishing that the mother posed a threat to the safety of the father or their child.
Don't our cases say, though, that once you have the two-party hearing, that is sort of your appeal, and I use that term loosely, of the ex parte order?
They do, but if this case ends up in the SJC, I would like the option of making the argument that the rule should change. And the other thing is that the presence or absence of evidence at the first hearing is relevant to the second hearing, so that if there was evidence supporting the issuance of an abuse prevention order at the first hearing, that would carry over and that could be considered. So I'm going to argue that the absence of any evidence at the first hearing is relevant.
So you want us to change the law?
I do.
And can we do that, or does the second floor do that?
Well, I think the second floor can do that. That's why I didn't press it. The notice of appeal has covered both, and I think that this may be a case that's ripe for that. But I'm not sure how important that is. But I'm making the argument anyway, and I'll leave it there.
So, on the extension of the order after the hearing, in denying the motion to vacate that order on December 29th of 2020, the judge says, the plaintiff testified credibly at the extension hearing on June 30th, 2020, that the defendant kicked him, poured hot water on his back, and acted erratically in connection with caring for their baby. He met his burden at the hearing, and the order was properly extended. So in light of those findings, how can we overturn the extension order or any subsequent order?
Well, I mean, I think we have to look at what actually came out at the second hearing. And, you know, the December order was not appealed, from what I understand. So I don't think it's all that relevant, but it's the same court, and
So just saying what was found at the extension hearing.
Right. I don't think the findings support that, the evidence supports that finding. I mean, here's the problem. Okay, so let me start with the first hearing. The first hearing, there was no discussion.
Ex parte hearing?
The ex parte hearing. There's no discussion of any incidents. There's no discussion of abuse. There's no allegations of abuse. The allegations were solely that solely on the mother's mental state and the fact that she would not take medication, and the father really wanted her to take medication. He believed that she should. And there was some concern that she might take the child to see her mother in Minnesota, and that might cause problems in bringing the child back. So again, there's absolutely nothing there.
So let me ask you a question. Let's assume that, for the sake of argument, we agree there's an ex parte hearing at which there is insufficient evidence presented to issue a restraining order. Judge issues it anyway. At the follow-up hearing, the extension order hearing where both parties attend, assume that there is enough evidence presented to issue a restraining order. What's the remedy under my hypothetical?
Well, if I get up to the SJC with this issue, the remedy might be everything fails. But I think under the current law, you look at what was introduced at the second hearing. And
So in a perfect world for your client, we agree with you when we reverse this and we
Yes.
vacate. But the next best option for you is we say, we disagree, however, there are problems with not considering the substance of the content of the ex parte hearing under our case law.
I think so. And I think looking at the second hearing, there are problems with the evidence presented there. So there were actually 4 incidents of alleged abuse. The first was during the child's first bath. There was an argument, and the mother kicked him and told him to F off. This was on March 26th. This was a couple of months before almost 3 months before he applied for the hearing. The judge asked some questions, and he explained, the father said he hadn't remembered it at the time of the first hearing, but he was videoing the wife and heard himself say, "Oh, why did you just kick me?" And the wife, in her testimony, explained that he got physical with her during that incident. Now, so that's the first incident, and
That's up to the judge to resolve that credibility dispute.
Well, it is, but there's no evidence that this kick was intentional, that there's no imminence here, because not only do we have to have evidence of physical harm, potential physical harm, but there's got to be some reasonable fear of imminent physical harm. And that simply wasn't there. This was 3 months ago. He hadn't remembered it. And then the water incident, the transcript isn't clear, but at one point she splashed him in the back with water, not scalding water. He didn't say that. He didn't say he was injured. He just said she threw water on him at some point. We're not sure exactly when this was. Now, there were 2 other claims of abuse, but the father seems to abandon these in his brief, and for good reason, because at some point during the marriage, she woke him up and told him how much she hated him, and then at some point during the marriage, she hit him in the face with a pillow when trying to wake him up.
Can I just go back for a sec?
Sure.
You said there might have been evidence of past incidents of attempting to cause or causing physical harm, but to get the order, he also needed to show that he had been placed in fear of imminent serious physical harm.
Yes.
So 209A1 has definitions of abuse, and the first definition is attempting to cause or causing physical harm. Second definition, placing another in fear of imminent serious physical harm. To get an order, isn't it sufficient to show abuse, or do you also have to show reasonable fear of imminent additional abuse?
I think it might be, that's hard to say. There may be a continuum. I mean, if there was a serious incident where she caused him physical injury, then maybe not. If there was an incident where we're not sure what happened, and he didn't even remember at the first hearing, and represented by counsel at the second hearing, he remembered it, but it wasn't much of an incident. There was a kick. We don't know if it was intentional. I mean, I think there's going to be more than that, and I think you can't just say, well, during the course of the marriage, things happen, and now I'm remembering it now that I'm looking for an abuse prevention order. The more remote it is, I think maybe the more serious it's going to be, or the stronger that evidence has to be, and it simply isn't there.
Can I go through the timeline with you of the restraining orders and the different extensions? My understanding is that the ex parte issued on June 17th, 2020. And then at the extension hearing, which occurred on June 30th, 2020, that was extended to June 29, 2021. And the notice of appeal was filed in July of 2020. So that was timely as to the extension, but not the ex parte?
I think it was timely as to the ex parte.
All right, I'll double check that. But
But
then,
I could be wrong, but.
on June 29, 2021, it was extended for another year to June 29, 2022, and there was no appeal of that order. Is that right?
There was no appeal. The last action is last June.
And then June 28, 2023, after another year, the extension was denied, and there was no appeal of that.
That's right. And I was one of the two lawyers who represented the mother in that.
But between the time of your notice of appeal from the 2020 to 2021 order and the denial of the extension in 2023, there was another one-year order that was not appealed from.
That's right.
So does that leave us in limbo a bit?
I don't think so. I think.
Because if we agreed with you and said I don't think we can overrule the SJC and the ex parte order. If you assume that the extension hearing on June 30, 2020 was the quote-unquote appeal, if you will, of the ex parte, how do we say the June 30, 2020 order shouldn't have entered, but yet then there's a June 21 to 22 order that was in effect and not appealed from?
My understanding, and from a past case where this was an issue, is that the subsequent orders would be deemed to be vacant.
Do you know
or
which
vacated.
case says that?
I don't, but I think if we, these orders can have significant consequences, and if we have an order saying that the first one never should have issued, and the subsequent ones were based on that first one, I think there's some benefit even if you don't end up vacating the subsequent ones. Now, the subsequent ones have no bearing on whether the June 30th, 2020 order should have been extended. So here's my problem with this whole scenario here. The father's argument throughout has been, the wife won't take medication. I want her to take medication. I should have the right to insist that she take medication. And that was the basis for issuing the ex parte order. That was a substantial portion of...
Wasn't that, though, in combination with a potential threat to take the child out of state?
That's something that should be addressed in the probate and family court. That's got nothing to do with 209A.
It does eventually, but it is part of the argument at the ex parte hearing that he was worried she was going to take the child and flee.
Again, that's an argument that should have been made in the probate and family court. That is not an argument that has any relevance to 209A. And then I think the judge probably said, well, I don't want this mother taking the child to see her mother and maybe not coming back, but what does it have to do with 209A? And it really has nothing to do with it, and that is the focus of the first hearing. That is really the focus of the second hearing. When you look at the second hearing, page 9, so I was just really concerned about my wife's mental state and the fact that she hasn't been taking any medication. And on page 25, I've been asking for her to go on medication. I've had concerns. And these mental health concerns are addressed on pages 21 and 22 on the husband's brief. And, I think the father may not like the fact that he doesn't have the right to make medical decisions of his now ex-wife, but that's a decision to be made by the mother in conjunction of her medical providers. The mother has a PhD in molecular epidemiology from Harvard, and she's perfectly capable of making these medical decisions in conjunction with her own medical providers. The father has no right to insist that she take medication.
That seems right, but does his motivation, or that might be part of his motivation for seeking this order, invalidate the order where he also testified and the judge credited that there had been 3 prior, or at least 2 prior instances of attempting to cause or causing physical harm?
I think pouring water on somebody and whatever vague allegation there is of a kick and with no injury that he didn't remember, I think his motivation is certainly relevant to that. And if this had not been a closed case, maybe his motivation isn't relevant. But if he shows up having taken a beating and having been injured, you know, maybe the motivation isn't that concerning.
Can I just ask you with a yes or no,
course.
are the parties divorced?
Yes.
Thank you. All right, thank you very
Thank you.
much. Sir, please come to the podium.
Hello.
Good afternoon.
Good morning. I am both the father and the victim in this case. And sorry, I'm not an attorney, so I might
Worries
look
at all.
down a little bit reading. But after 4 arduous years, Mother's efforts to misrepresent and selectively omit parts of the events of June 2020 through her legal representation and under oath have continued. Without any cause to do so, she called the police on June 14th, alleged that she was in danger, and this capped off a chain of events of abuse whose escalating nature necessitated a protective order, helping to ensure the safety of all involved, including our child. I have lived this for the last 4 years, reliving these events, trying to understand if there was something different I could have done. Sorry.
Don't be sorry, take a moment.
But the saddest moment in my life was realizing that her behavior had escalated to the point where it might end our family. And trying to understand what I can say and do to make sure that everybody was safe, both at the ex parte hearing and the contested hearing, was very difficult because my intent during those hearings was to make sure that we came out of that and that reputations weren't damaged by wild allegations or me essentially dumping every problem that I'd had and experienced over the last year. I had lost my father in 2019, and we had, at the end of 2019 in October, and we had our baby shower at the beginning of 2020. There was a little bit of emotional whiplash going on. And I want to make sure I'm sticking to the facts that are in evidence, and so there are things that I could speak to and things that I can't, and I want to respect that. On the issue of the arguments made by the Mother's Counsel, I do want to clearly state that I in no way at any time wanted to in any way control her medical decision-making. The court has access to the Guardian ad litem report that was issued in May of 2021. That is not in evidence for the extension or the original tripartite order, but it makes clear the lengths that I have gone through in working with her doctors to make sure that I am contributing and not in any way pushing her to make medical decisions. It includes interviews by her doctors on behavior that I participated in towards.
Just so you understand that, that's not something, unfortunately, that we can consider.
Understood.
We're very limited to consider what the judge did in the district court, not even
Exactly.
in the probate court.
And I guess I'm just offering it as context for
Understood.
what was said earlier.
There's no longer an order, is that right, after
Yes.
June of 2023?
There is no longer an order.
And you are divorced?
And we are divorced, and that, I believe, was absolutely a consideration with regards to the extension of the order. There was no longer ongoing litigation.
Can I ask you, when you applied for the order in June of 2020, that was during COVID, right?
Yes.
So it was your hearing on the phone?
The initial hearing was
Initial
on the phone.
And you didn't fill out any paperwork because it
No.
was COVID?
Exactly.
Okay.
And so I think a lot of the record was incomplete, and this was reviewed at the contested hearing. We moved forward, trying to at least establish what was actually going on, with both parties being represented. As part of my argument, I was noting that the standards were met, in particular for the contested hearing, and that the order for the minor child was proper, considering what had been going on with regards to her involuntary committal to the hospital for 3 days. Can I speak to the motion to vacate?
So that motion to vacate was filed by your former wife in October of 2020?
Yes, we had a hearing in December 4th, 2020.
And that's between the time of the extension hearing and the 1 year? So yes, you can speak to that.
Okay. In that extension hearing, there were a lot of assertions, many of the same assertions that Attorney Curhan makes in his argument, that, for instance, the order on the minor child was not proper, but considering what had occurred with her committal, or with her, the order, the Section 12, due to concerns about her mental health, that was proper, and the concerns were real. My concerns were really about the sense that nothing that was going on with her made a lot of sense, and there was a distinct, I guess, difference between what she said to the police and what has been clearly documented throughout all of the different affidavits that have been submitted before the court in each of the different hearings, and what she said to the hospital to get discharged. In getting discharged, I believe on June 17th, she said that she did not believe any of the things that she had alleged, that she did not believe I was filing her fingernails, or twisting her wrists while she was sleeping, or scratching our baby's face, that none of that was part of what she believed. But this was what my life was up until that point. Constant allegations around sneaking into the nursery and doing things. These concerns were substantial because, from her perspective, evident by her actions, which I believe she saw as protecting her son, me walking past her in the morning to say hello to my son, her washing a pot and taking that water and throwing it on me. It was shocking, it was disturbing. I immediately started trying to record the incident because I know that given past incidents that what actually happened starts shifting. And it's really difficult when you have somebody in your life whom you can't tell if they're lying or if they really believe what they're saying. And it's extremely difficult. And so I was shocked when she said in leaving, in the discharge from the hospital, that she was withholding all records from not just myself, but from DCF. I had no idea why this was happening, but she felt it was her right to not tell us anything. In the motion to vacate, her attorney, Michael Thaler, put forth that that I was in full knowledge that she had been given a bill of clean health, and this was simply not true. He put forth also in the subsequent deposition that I did with her lawyer, a different lawyer.
I don't think the deposition's before us right now, so.
It was part of the motion to vacate, but.
Okay. Is the motion to vacate the denial of the motion to vacate being appealed? My understanding is it's not.
No.
Okay.
Okay.
So
moving on.
Thank you.
A lot of these things really just contributed to my realization of the danger that was before us during that time. As I've commented elsewhere, it's been very difficult to try to understand where you are, where you are is someplace that you've never been before with regards to a relationship and legal jeopardy or anything with regards to a legal system that I've never actually in any way had run-ins with. And that's the number one reason why I approached everything with so much caution. And so that's basically the situation that I found myself in on both the initial ex parte hearing and the contested hearing, where I had to accept a lot of the things that I did not want to accept was happening. And it's still hard right now, just trying to just accept that things are the way they are, not the way that I want them to be. And trying to protect people is not really in the best interest when you are charged, as DCF told me very clearly, with putting our child's welfare first. In addition, the motion to vacate was proper, the denial, and I also, in my argument, brought up issues around the timeliness of the appeal. I'm not really sure how we're here 4 years later after the appeal, after the initial restraining order was granted, and then, after a year after it has expired. But I can understand some of the context of what's currently happening. Ultimately, what I am left to try to impart to the court is that I can still empathize with the sense from her that she doesn't want to feel bad for what she did, but that doesn't give her the right to erase what happened. That this is not about how she feels. This is about the facts and the protection of people who can't protect themselves, or the protection of people like myself who is struggling with being put in jeopardy in a way that I've never been put in jeopardy before. I'm hoping that this is understood and appreciated by the court, that the rest of the arguments that I have made are appreciated. I did want to make 2 technical notes. I did, being pro se, I didn't quite understand that 2 of the failures to appear were actually by the plaintiff, which I guess was technically me. I listed that as instances of her not following up with any request for appeal, and me not understanding. The original appeal was filed by Michael Thaler, who then filed the motion to vacate, and then I think it was taken off the court record as representing her sometime earlier last year. But then also, I guess I did want to also note that in addition to the dates, there was some other error that was in the documents. But sorry, it's actually not coming back to me right now.
That's okay.
Yeah.
All right, well, thank you very much for your argument. The case will be under advisement, and we will issue a decision. Thank you both.
Okay. Thank you very much.
Our final case for the list this morning is 23P 1147, Stephen O'Malley and another versus Contributory Retirement Appeals Board and another. And I just want to make sure I understand, on the appellee side, you are splitting your time equally at 7.5 minutes?
Correct, Your Honor. Yes, Your Honor.
Mr. Shenoy, when you're ready.
Good morning, may it please the court. I'm Praveen Shenoy. I represent the plaintiff appellants. The issue here involving Chapter 32, and from my reading of all of the cases that I could on this issue, somewhat deals with regular compensation. And I want to point out that, as the court's aware, the administrative process requires that at some point before an administrative law judge, a determination is made as to whether work, in this case, crossing duty or traffic duty, crossing guard duty, is regular compensation.
So could I ask you about our standard of review? Because if CRAB concludes that crossing guard pay is more like overtime in the sense that it's irregular and hourly, what is our ability to disagree with that?
There is no ability to disagree with a determination at the administrative level unless, I mean, there's the ability to send it back if it's not based on the proper
So if it's
legal
arbitrary or
standard.
capricious, which you're not arguing it is,
Well, we are arguing that it was not based on substantial evidence.
because of your client's expectations?
No. So the expectations, I mean, that would be great if, a retiree's expectations were upheld. Clearly, that would not.
Would send the system into chaos.
Correct. So that's a step. So I guess there's that sets forth two different parts of our argument. One is in determining if this is regular compensation, and I'm going to say DALA because essentially CRAB adopted DALA. So at that initial level, there was some fact-finding as to whether it was regular compensation. And to show the difficulty is, this is clearly, as case law has said, a very difficult area of law, not just for the courts, but for the attorneys who are trying to interpret what the courts have said. The DALA decision actually says that they were regularly receiving traffic duty pay. And so from that point of view, now you have a DALA decision saying that this was paid on a regular basis. And
But sometimes it was for just about 6 hours a week, sometimes 2 hours a week, sometimes 4.
Correct. And so.
And it was paid at time and a half.
Yes, there's no doubt that this was paid.
Obligated to do this. They did it by choice.
Correct.
And the hours were different at different times. Let's put it that way, if you went week by week or month by month. Okay.
Yes, there is no doubt that at first blush it looks like this is totally a case where someone is asking for what is not allowed, which is overtime.
No, I recognize the nuance to this. This is not a clear-cut case by any means.
Correct. And so what we have looking at it is a problem with the DALA decision ultimately is, the preference would be, given how long this case has been going to, from the time it was appealed until now, would have been to receive an adjudication of some type. But unfortunately, because of I suggest it's because of the complexity of the law, not by anyone intentionally doing this, DALA didn't address, as to its fact-finding, the actual period that it should have. So we had,
I want to focus on that. So you say that Dalla wrongly used a test period which was after the injuries occurred to determine how regular the traffic payments were.
correct.
So even assuming that that was an error, you wouldn't get relief unless that error prejudiced your clients.
Correct.
So you would have to show that if Dalla had used some other test period that was more appropriate legally, a different result would have been issued, or a different decision would have been issued. So my question is, what different period do you argue should have been used as a test period? And how would that have benefited your clients? Because when I looked at the long spreadsheets in the record for the 1 year period before the injuries, it seemed like the traffic payments were all over the place. Some weeks nothing, some weeks 10 hours, some weeks 2, 6.
Absolutely.
So how would that have produced a better result for your clients than what the test period Dalla actually used?
And that's one of the issues here. There's case law as to salaried employees, for example, teachers, who are on a salary, which clearly identifies, and that's the Hallett decision, that hourly pay is a no-go. You can't get any kind of benefit from that. But here we have employees of a school department who are paid hourly, and so it would be, expected that crossing guards are not performing this service when the students are not there, which would be why there's a difference in the amount. There's nothing in the statute
But does the record show that the variations from week to week were because there was a holiday or a short day or school vacation or anything like that?
I believe it does, Your Honor, in the testimony. So there was testimony taken at the Dalla level, which is in the record. But I don't think that's as much of a concern as the fact that there's a variation in the amount.
But for purposes of I'm sorry, I don't want to interrupt Justice Say, but for purposes of our understanding of the record, you don't disagree that no matter what time period we look at, the hours varied week to week, month to month, et cetera, for a variety of reasons, correct?
Correct. It is a fact.
That's just not disputed.
Correct.
Okay.
Yes. And that's adding to the level of complexity here, which, despite that, and this going back to Justice Blake's initial question about, I think it is, at least I had answered, there are 2 areas here about the reasonable expectations. With all of this said about the complexity of regular compensation and how the courts have allowed and it's in, I believe, one of the appellant briefs, dealing with how the board would initially make that determination, meaning the Brockton Retirement Board. And it had a practice of allowing that as regular compensation. Now, I understand they might have been wrong, but that's the way that it reads is that's their determination of what it was.
Are you making in this regard an equitable argument? It almost seems like you're making an argument akin to an estoppel argument. They accepted this practice, they being the Brockton Retirement Board. They allowed this, so my clients therefore had a reasonable expectation that because money was being taken out and put into retirement, that they would get it back on the back end.
Well, yes, Your Honor, and I'm fortunate for the argument. I wouldn't dare to do that without some kind of authority because it's appealing to equity in this scheme of the retirement system is very difficult to do. Instead, I'm citing to the opinion of justices in the brief. And
that's about changes in legislation that can't be made if they would destroy reasonable expectations based on prior legislation. Correct. This is a policy that the board followed based on, I guess, its interpretation of a statute that PERAC, I believe, through a memo subsequently said is wrong.
That's true.
So how
but
does that
Dalla-
implicate the principles involved in the opinion of the justices?
So it's Dalla who found that it was the board instituting a new policy. That's not me just saying that. That's Dalla actually found that.
But how does that implicate these constitutional concerns? That the board instituted a new policy based on having been informed by PERAC that it had been misinterpreting the statute.
Correct, and I didn't understand from my reading of opinion of the justices or, Colo, that it was a constitutional concern as much as the SJC saying this is how retirement systems work in most of the states. That was, so I don't want to, represent that I understood that there were any constitutional concerns, but certainly where you have a retirement board who, I just want to point out, this happened after these my two clients filed for retirement. This wasn't before they filed for retirement. It was in the course of their application for accidental disability retirement that this occurred.
Your clients did get the money that was put into the retirement, that was taken out, that went into retirement. That was refunded to your clients. Is that correct?
No, not yet.
Okay, it's being held.
The judge ordered it.
Yeah, that's my
The
understanding.
judge ordered it, but pending the appeal of this matter, that didn't enter as a final judgment.
I see. But, well, I can ask your brothers whether there's
And
any
I don't
dispute that
believe-
they will get that money back.
Yes, and that representation was made by the retirement board in front of the Superior Court, and that's on the transcript.
So you just cited the Colo case. The appellees go to great lengths, and I'm talking in particular about the Crabb brief at pages 22 to 24 to distinguish Colo. Tell me why the distinctions they make in their brief from the present case are incorrect.
As to Colo?
Yes.
So Colo is dealing with the Athol Fire Department, and I believe the distinction that the appellees are making is
It was a legislative right, and therefore when the law changed,
right.
that right stayed with them, for lack of a better explanation. Whereas in this case, we're dealing with the board's interpretation. We're not dealing with a statutory right.
Correct. So in Colo, you have, Colo was a full-time employee at the time, and in there it talks, I don't remember the exact line, but it talks about how everyone else had been part-time, and that the board had given that part-time status or found that to be compensable time. So it is definitely different because here we're dealing with a decision as to what is regular compensation.
We're dealing with an administrative agency's interpretation as opposed to the plain language of a statute.
Correct.
Okay.
Yes, and and again, there is a lot of grasping at straws. There's no doubt, but one of the issues that makes it tough for the appellants is the dollar determination of what regular compensation is doesn't seem to be based on either looking at the right time period, if that is how they're doing it. And again, we can't question what DALA did because we're just basing it on whatever the decision said. As an agency, they're allowed some deference. I mean, whatever we believe it should have done is really not what we're dealing with here.
I want to come back to the question I asked before.
Yes.
You say DALA used the wrong test period. What test period should they have used, and how would it have made a difference to the result?
So DALA sent out a preliminary order as to this issue, and I believe it's cited in my brief as to saying it's only whatever period counts that they wanted. So DALA said, well, we're only going to look at either the year before the injury or the last year of compensable pay. I submitted all of the hours, arguing that all of the hours should be looked at on a yearly basis, because this was something, so unlike ad hoc.
Can you try to give me a simple answer, or give us a simple answer? Which period should DALA have considered, and how would that have made a difference to the result DALA reached?
Okay, so DALA had looked at whether this was ad hoc or overtime, payments. And even though these were different amounts of hours, if you look at the year before the date of injury, there is regularity, and DALA says that they were regularly paid. So that's what I mean, yes, it would be the year before is what we contend, because the year before they were found eligible, they weren't working. So they weren't doing traffic duty.
But again, you don't dispute that even in that year prior that you're referring to now, that some weeks they worked certain hours, other weeks they worked less, other weeks they worked more.
Correct.
There was some disparity along the way at all times.
Correct, and DALA didn't make any determination
As to whether or not that constituted regular versus irregular payments.
Correct.
Got it.
Yes.
All set, thank you.
Thank you.
Thank you very much.
Thank you.
We are going to hear next from Attorney Galvin.
Yes, Your Honor. Gregory Galvin for the Appellee Brockton Retirement Board. First, I must clarify, DALA doesn't set what the retirement benefit is going to be. The retirement benefit is calculated by the local retirement systems. That calculation is then sent into PERAC, and that's how they determine that the traffic pay appears to be overtime. It wasn't identified as overtime because there was in the
So up until that time, did your client believe that the contributions from this fund were part of the superannuation calculation?
They were submitted by the school department as regular compensation with retirement benefits.
While you were withholding the money.
Withheld. And they came into the retirement board that way. It wasn't until the two appellants filed for a disability retirement. At that time, we had to get their payroll records.
And that's when you realized it was overtime?
And PERAC realized it, in
So
their
before
opinion,
these-
overtime, and we agreed.
Before these two individuals, O'Malley and Lambert, had your client been, I can't imagine these are the only two people that have ever done traffic duty in the city of
Right.
Brockton. So had this ever come up as an issue before?
Well, yeah, number one, there are traffic crossing guards. However, the custodians and the school police fill voids, holes in crossing guards.
So somebody
having
who
to-
is just a crossing guard, not custodian or police
Correct.
officer by day, but just a
Correct.
crossing guard,
Correct.
is their traffic pay regular compensation for retirement purposes?
If they earn $5,000 a
Right.
year, et cetera.
If they
so
meet
yes.
all the other thresholds?
Yes.
But if
Correct.
they were doing something else in the city, let's, not even related, a DPW worker and filling in as a crossing guard, the so-called, I'm going to call it the O'Malley-Thomas rule would now apply?
Correct, so long as they would meet the other criteria. In this case, their contracts said, Mr. Lambert, you're a custodian. You work 8 hours a day, 40 hours a week. You must work those hours as a custodian every week. If you want to work crossing guard duty, it's over and above. It's extra, and we'll pay you a premium, time and a half. It's not part of your regular duties to be a crossing guard. School police, O'Malley, same thing. You work your 40 hours a week. If your crossing guard duties interfere with your normal 8-hour day, you have to make up the time you spent as a crossing guard later in your shift as a school police officer. So if your shift is over at 11 o'clock, but you worked a half-hour crossing guard, you don't get out until 11:30.
And the
So-
fact that this was triggered by a disability retirement really doesn't matter, right? It could be any kind of retirement.
Correct. Correct. And it's the retirement board, along with the oversight of PERAC, that determines the retirement amount.
And it's because disability retirement calculations have to be submitted to PERIC for approval, but what, superannuations do not?
They don't submit the full calculations, yes. Because disability retirement is 72%. Okay.
The bigger deal.
Yes. So in this particular case, both appellants testified that this duty as crossing guard was separate and distinct from their regular duties. And they got paid a premium, and it occurred throughout their tenure. In this particular case, Mr. Lambert's tenure, because it was only from 2002 to 2010 when he went out on his disability retirement. Mr. O'Malley's case, it wasn't quite throughout his tenure, but through a significant portion of it, and they got paid as if it was overtime, time and a half, and that's what they testified. Their overtime rate, time and a half, and that's what they got. Yes.
So how do you deal with the fact that Dalla, apparently the Dalla magistrate, said, oh, well, they do this regularly? And
Well,
is that just a slip of the tongue that we should ignore?
They would.
Or, I mean, if it's regular, how is it not regular compensation?
Well, it wasn't regular in that it was available 52 weeks a year. School vacation, there was no crossing guard. So they would work as a custodian or a school police officer. They still had duties, but they didn't do crossing guard duty. Some of time, no crossing guard duty. So it wasn't regular in that it was 52 weeks a year.
Regular means something different when we're talking about regular compensation, right? That there's a statutory definition.
Correct, yes. And
And I'm not foreshadowing the result here, but in the event that you're successful, there's not a question that their monies are going to be returned, right?
No, as a matter of fact, we have a number of custodians. I get a phone call at least every 6 months. What's the status of their withholdings? I said, well, until I know that this case that's on appeal is finalized, we can't, because if Your Honor said, oh, no, Dalla was wrong, Crabb was wrong, Judge Wilson was wrong, it is regular compensation, then we would have to calculate the other custodians and school police that do some of this, because it's not all custodians, it's not all school police that do it. Because again, they're fill-ins, they're not the regular job. With that, unless there's other questions.
I don't think so.
Thank you very much.
Thank you.
Thank you. We'll now hear from Attorney Batchelor for the Attorney General.
Good afternoon, Your Honors. Andrew Batchelor on behalf of the Contributory Retirement Appeal Board.
What does regular mean?
As you suggested earlier, Your Honor, the question isn't what regular means, but what regular compensation means. It's a defined term.
In Chapter 32?
Exactly. And those two words together, the meaning of them as a term of art is what matters. And so if something is regular in other ways, that does not necessarily mean it is regular compensation. For example, if someone were to receive the same overtime payment every day for 20 years, that's still not regular compensation. They're getting it like clockwork. It's regular in that way, but it's not regular compensation because it is overtime. And if we step back for just a little bit here, everything about the traffic pay for these two plaintiffs looks and talks and acts like overtime. There's really nothing to distinguish it from overtime, except it's even further removed because it's for a different type of work than their regular work.
But a crossing guard who's only a crossing guard, not a custodian, not a police officer, not anything else. just a crossing guard who probably doesn't work 40 hours a week, and their hours might be irregular in the colloquial sense that there's school vacations, snow days, and the like, are their wages subject to the retirement withholding?
I don't have an example like that in front of me, so I can't say. I don't know if those have been withheld or not. I only have these plaintiffs in front of me. And the fact that it's well established in the law that if a employer erroneously withholds payments, sends them to retirement board, the solution is to refund those payments.
So it's not so much that they are, if you will, these are my words, part-time crossing guards, but they're part-time crossing guards on top of a full-time job.
Yes, Your Honor. That additional irregular work does not fall within the scope of regular compensation.
While I have you, this may be my last question, and I promise I'll let you argue. You phrased the statement of issue as to whether accidental disability retirement benefits are calculated using regular comp. And I asked your brother, and I just want to confirm with you, that this is disability versus age-out retirement is really not the issue in this case, is it?
It shouldn't be, Your Honor. This gets into several things I don't think we should get to.
Okay,
so,
then forget I asked the question.
well, I think I can address it just very briefly, an abundance of caution. The Colo decision, as was already pointed out, we go into great detail how it doesn't apply. Colo relied on a section of Chapter 32, 25.5, which is the statutory reason why changes to a statute are not always applied retroactively, depending on what was in existence before. There is a case that specifically says that section doesn't apply to accidental disability retirement benefits. So we don't think that section applies for any reason, because there wasn't a relevant change in the statute.
Okay.
But if for some reason there was a disagreement or reasonable expectations, if there was a change in the law, reasonable expectations would matter, which again, strongly argue does not, then the plaintiffs would still lose because accidental disability retirement benefits don't enjoy the protection of 25.5.
You're saying 25.5 doesn't apply to accidental disability retirement?
Yes, Your Honor. And that case is Ouellette versus Crabb, 86, Mass Appellate Courts 396, 2014. It's cited for other reasons in our brief, but it talks about 25.5 being inapplicable to accidental disability retirement, as it only applies to retired for superannuation. Again, I don't think we should get there because that statute doesn't apply, but since you asked.
I have a few questions. The first one is, you have a section of your brief entitled Plaintiff's Expectations Do Not Control. Are plaintiff's reasonable expectations a factor in any way in the analysis?
No, Your Honor.
Okay. And your authority for that is?
Several. I'd say the one the best quote, I have that from one of our cases, would be Clothier, which talks about, because this is set by statute, the limitations apply by statute, and their expectations to the contrary are not relevant. I can pull up the direct quote in a moment.
No, it's in your brief. That's fine. And the second question I have is, briefly, but with specificity, could you explain exactly why the timeframes are inapposite here? Or if not inapposite, why that argument fails?
I'll do the second part.
Do you understand the question?
I believe so. The plaintiff's argument is that the wrong timeframes were used, and our response was no prejudice was shown by the alleged wrong time being used because all of the timeframes are in the record, and as Justice Sachs asked earlier about prejudice to the plaintiff, if there was any possible prejudice to the plaintiffs here, they could have pointed to that record and identified a way why the result would have been different using any different time frame, and they did not. And here during our oral argument, they again conceded that the time, the amounts paid varied during all time frames. Does that answer your question, Your Honor?
It does. You said you had two parts to your answer, but if...
Why it's not relevant. I would also add, and it's not, doesn't come up here because plaintiff agrees that it varies from time to time, but I would suggest because this is so much like overtime, it's paid at overtime, even if there were a time period where the plaintiffs were being paid the same exact amount every month, that would still not be enough. We don't need to go there in this matter because they concede that their pay is varied, but it's not a dispositive issue because this is so much like overtime.
If you have something else to say, please do so. We didn't really let you get to your argument, so I apologize for that.
I'll just add, in closing, I'll mostly rest on my brief. The plaintiff didn't raise estoppel as an argument here. We cited to every other, all the cases talking about how reasonable expectations don't apply, but also estoppel would not apply, and there are several other cases.
Because it can't trump a statute. Is that fundamentally the reason?
Yes, Your Honor. With no further questions, CRAB will rest. Thank you very much.
Thank you. I want to thank all counsel for excellent briefs and oral arguments. It's a very interesting case. It will be taken under advisement. That concludes today's sitting. I would like to thank Mr. Guarino, our court officer, and our excellent timekeeper. Have a good rest of your afternoon. We're in recess.
All rise.